What we are discussing today is really about IP law, or intellectual property. So as a business owner, there are some components of the IP law that are useful to get to know. So we'll be discussing 4 areas in depth as those are like the areas that are very useful, right? Right. So let's just jump straight in. So when we talk about intellectual property, so we'll be calling it IP for shortened form, because then it's easier to kind of understand, right? So there's a big body of IP law globally, and there are lots of treaties as well for which Sri Lanka also has tied up. So how IP law really works is there are very important conventions. And when a country goes and ratifies these conventions, then there are certain things or certain rights and privileges which those countries' businesses automatically get. So if you really look at the law, it regulates the creation and it regulates the use, and it also regulates exploitation of what we know as mental or creative labor. So intellectual property actually talks about the mental or creative labor, and it ensures that you are protected from unfair competition. So we'll speak a little bit about what this unfair competition, how can people exploit and things like that. So generally when we say IP is a big body of, when you say intellectual property, it has a big body. So some of the most common things would of course be literary, artistic and scientific works. So things like books, scripts, music, lyrics, paintings, performing arts, photographs, podcasts, all of those fall in. Then also inventions in the field of human endeavor. So all these creations that we make, like industrial designs, like a specific shape of an iPhone, specific shape and look of a particular car model. So all of these fall in there. Also pharmaceuticals, then genetically modified animals, plants, and all of these marks that we put in to kind of identify our own brands. So all of these, or sometimes even a specific name for your company, all of this really falls into intellectual property. So you can limit these intellectual property in terms of who else can create it, who else can use it, and if someone else uses it without your authorization, what can you do about it? So when you really look at intellectual property, it is intangible, meaning you can't really touch it. Some of it, yes, you can, but actually you can only touch the physical article which contains it. But really the design, now even if you take jewelry, there is like a specific artistic form that it takes. Yes, there's a physical article, but there's also a design element to it, which is intangible, right? So when you say intellectual property, actually it is intangible. And it can be separated from the physical article. So even if, let's say, I made a particular handbag, right? And say and it's a specific style, and you have patented it, right? Or maybe you have even trademarked it, right? So say if every single handbag gets destroyed, right? Still, the intellectual property will contain, right? Because the design element of it will always exist. So similar when it comes to books or even a jewelry design or anything like that. So, so that's a little bit about intellectual property. Now, if we really look at the importance of intellectual property, now, why is it so important? And there's no other country that considers intellectual property so important than the United States. And you can really see that they are, I'll be showing some statistics with you, which compares Sri Lanka and the states to really understand economic importance and the positioning of IP in and the financial rewards systems that are there when you do really have IP in your specific country. So in USA, the IP industry, intensive industries. So it's like the software companies, but apart from that, you have all the mobile applications that are there, and also lots of other inventions that they make, be it in the medical industry, pharmaceutical industry, all of it. It supports 45 million jobs in the US, and it contributes to $6 trillion of their GDP. So that's 38.2. So you can imagine the amount of financial gain in intellectual property. So this is, it's really a great tool for economic development. So if you generally take intellectual property rights, what's important to note is that intellectual property are generally territorial. So meaning they are only valid in the country in which they are created or registered. So you need to remember that. There is one exception, and that exception is with regards to copyright. Copyright, you don't need to go and register, apply, we'll be talking about it, but just remember there's one exception, and that one exception is copyright. That is, the moment you create it, you are given protection. But when it comes to other types of intellectual property rights, they are territorial. So if I produce something in Sri Lanka and I go and register it, it's only applicable for Sri Lanka. So if I want to go and get it applicable for India, Maldives, or so on and so forth, we'll be discussing those. How do you go about doing that? So if you want to protect your IP abroad, then you have to really seek protection in each and every country according to that specific country's law. As I told you, for copyrights works, there is something called the Berne Convention and TRIPS Agreement, which provides for automatic protection within member countries. So when we say member countries, there's more than 180 odd countries who have signed up into these conventions and agreements, right? So we'll be speaking a little bit about international organizations who have these conventions. So one of the big is the WIPO and WTO. So we'll discuss those also as we go along. So as I said, IP is territorial. So in terms of Sri Lanka, the act is the Intellectual Property Act number 36 of 2003. So this is the act that we use. But apart from that, as I told you, we've signed into the Berne Convention and TRIPS Agreement. And so some portions of it are automatically applicable for us. If an intellectual property right is violated, there are two types of actions that you can take. So that is called civil liability, and also you can take criminal action. So we'll be talking a little bit about those two as well. Civil liability is basically, I have intellectual property right, and if someone infringes it, for example, someone makes a counterfeit product, or someone uses a mark that I use on one of their goods, then you can sue them for civil liability. So we'll speak about what are the benefits that I can get as well by suing. So it really doesn't matter whether you are unaware that there was a particular trademark like this, right? It really doesn't matter, because as in the general principle of law is you're expected to know. So if your unawareness is your problem, and generally you are expected to learn the law on your own, right? So you can't take the excuse of I'm sorry, I didn't know, or I would rectify it. If you are sued, then you are liable to pay for whatever the damages or compensation that particular company or person will be asking from you. Right. So this is the International Intellectual Property Framework. So there is the World Intellectual Property Organization, and it has really 26 treaties. And so these are two international frameworks that govern all of the intellectual property globally. So as I told you, there are treaties and conventions which governments go and sign into. And the World Trade Organization also has an agreement, and it's generally called the TRIPS agreement. So the abbreviated version is that, but the full name is Agreement on Trade-Related Aspects of Intellectual Property Rights. So this is just some background information so that you all know how the IP framework works globally. Because as much as it is territorial, once you get to know a few things, you know that this would probably be the same way it is applicable in other parts of the world as well. However, the registration process and the fees for registering intellectual property may vary from country to country.
Right.
So these are the Sri Lankan statistics. So you can see all the way from 2010 to 2019. These are the three general, broadly speaking, registered intellectual property. You have patents, trademarks, and industrial designs. So you can really see the number. In 2010, only 143 applications.
It's almost double by now.
Yes, by 2019, it has only like still very small, 412, right? Trademarks, 5,000. And in 2019, 7,000, right? So you can see it's a very slow progression for a 9-year period. You'll understand why I call it slow when we move on to the next slide. Now look at the states, okay?
Yeah.
We're talking in millions and hundred thousands, right? So in 2010, they had 433,140 patents and trademarks, 1.1, million, nearly 1.2, right? And in 2019, so you can see for them, it's a constant, right? So they may be fluctuating, but their average has always been
more or less been the same.
Yes, so you can see how strong they are.
But the trademark registrations have grown comparatively to the patents and the industrial designs, if you go to see.
Yes, that's right.
It's grown significantly.
It has grown significantly, but you can see from 2010, they've been on it. So you can imagine how vast that economy is, right? Especially when it comes to intellectual property, and how very small and also insignificant the Sri Lankan IP, how Sri Lankan IP is, right? So the statistics are really there so that you get a good understanding about how things are, and that will also help you to know why we are where we are and why certain countries are far ahead of us.
But it's also a mindset, right? Like over here, it's all about like maybe either entrepreneurship or then about, like working under a company as a job, like to get a stable income. But they don't know how to apply certain things. And because we have limited resources to manufacture and the tax rates are such, I think there are many factors, I would say.
Yes.
And again, the mindset, the cultural mindset that we have here is different from what they have.
Correct. So, because they are very entrepreneur, as you very correctly said, right? They are very driven. It's a very capital-driven market. And also, when you file something in the US, your market is huge. Whilst when you file something in Sri Lanka, I think I don't need to explain it, right?
No, it's true. What you're saying is true. The market here is, it's saturated for what you're doing. Even what I'm doing right now, in the last 2 years, I think I find it saturating even more.
Correct. And I think it would be, for me, it has grown simply because of some of the sectors that are working with the US. And these are not local companies. So the local companies, as you said, it's very, again, the mindset and all of it plays a real big role.
No, it does, because it's easier to, I think, deal with people abroad. I mean, my experiences with even some of these BNI one-to-ones that I'm having with some foreign members, it's better with those than the ones in India or Sri Lanka. Indians don't understand. It's the same situ as here. And they'll get the, information or whatever, and they apply it elsewhere. So I stay away from it now. It was a learning curve, and I know where I need to, get involved now.
Correct. Very true. So I think we have two more joining us. We have Abdul and Christo. So we've already started the lecture, so I'm just going to go on as we were, right? So so if there is any questions, please feel free to unmute, because it's just 3 in the class, right? You're very welcome to unmute and ask or make comments, right? No problem at all. So if we look at, so hold on, my screen got stuck. Right. So there are 4 types of intellectual property that are really relevant for us when we are talking about that. This is not to say there aren't others. There are, but these are the 4 types that are useful for us, right? So when we talk about, so the 4 are trademarks, copyright, industrial design, and patents. So if we take a trademark, these are specific definitions that I have given you, so that you kind of get a little idea about it before we jump into the topic. So a trademark is really, it's a visible sign which helps you to distinguish either your goods or your services. So when we generally, I think you have all heard of the word trademark, but you may not have heard of the word service mark. But a trademark is given to a trade. A service mark is given to a service that is being operated, right? So, so it's really any kind of a sign. It can be numbers, words, things like that. So I have a question for you. In the 4 logos that are there, you can see that some has a R, like, I don't know whether it's very clear to you, but there is like a R symbol in most of these actually trademarks, right? So the R really stands for that they have registered this trademark. There may be certain logos that you see which doesn't have the R. So that means they may not have registered it. So we'll talk about what's the purpose of registering and not registering, so on and so forth, when we are talking more in depth about trademarks. So when it comes to copyrights is given by law to the creator, so to the author, for any of their literary, dramatic, musical, and artistic works. So things like novels, scripts, poems, drama scripts, movie scripts, lyrics, all of this is what we consider as copyright. So registration is not required for protection. I'll tell you a little bit about what does that really mean when we jump into copyright. Industrial design is actually the aesthetic aspect of an industrial design. So if I give you example, it's really about the appearance, the ornamental, like an aesthetic appearance, right? So the appearance of an iPhone, the appearance of a particular car model, right? There are also some like in the more luxury handbag ranges and all, they have this very specific padlocks that don't really, they're like locks, but they're not really to lock your handbag, but it's more of a design element, right? So those are some of the things that make a particular product valuable. And these are what we call as industrial design. So remember, this is generally when you hear the word industrial design, you're actually going to think it's some kind of a mechanical, like a kind of designs, but it's actually the aesthetic aspect of a industrial article. What we mean by industrial article is really any article which has some kind of a purpose or utility value or anything like that. And we are just talking about the appearance, not really about the blueprint or anything about of how a particular product is made. That is actually governed under patents, right? So this is really the rights which is given to the inventor for scientific or technical invention. So some kind of a software development, any other form of formulas, designs, any of those can be considered as patents. So I think one of the most very familiar patents could be also these electrical batteries in vehicles. You can see each model has their own specific technology. So they have all patented those, right? Then you can also look at I think now it's probably no more, but earlier we had this thing of the door cooling refrigerators, right? So that's a specific technical invention, again patented, right? So please remember, industrial design is about appearance or the aesthetic value of it, but patents are really about the scientific and the technical inventions. So these are the 4 types of intellectual property that are useful to us. Right, so now I am going to jump in to each one of them and explain to you how the process of registering in Sri Lanka and some of the advantages and disadvantages as well. So if we take a trademark, one of the key things to understand in a trademark is that a trademark is a visible sign, and it has to be able to distinguish goods and services from other companies or other enterprises. So this is a key element. So whenever you're going to register a trademark, what the trademark of what the National Intellectual Property Office of Sri Lanka would also do is to see this. Can you distinguish this product or this service from other companies? So if it's vaguely, it's like similar to something that's already in existence, then they will not allow you to register that trademark. So the trademark, as I told you, is related to goods and also services. So when it comes to trade, we call it trademarks. When it comes to services, we also call it service marks, right? But of course, the predominant word that is being used is trademarks. So the trademark of any trademark that you have seen, it can even be a company name, like simple things like Maliban, right? Manchi, these are all company names, but apart from that, they may have specific trademark goods, like I don't know which brand has it, but someone has super cream cracker, then there's someone with a specific, lemon puff, all of these are trademarked, right? So it can be a word, it can be symbols, it can be letters, numbers, a name, a surname. A combination of this arrangement is also possible, and it can come in various colors, shapes, all of that, right? So you all are very familiar with this. All you have to do is really look at any any brand out there, and you would understand the creative potential in creating trademarks. So it is this ability, because it can be anything. It can be a word, a symbol, letter, numbers, combination, colors. It's because you have been given so much of freedom that it is expected that whatever the trademark that you're trying to register can be easily distinguished from other enterprises. So that is an important thing to remember when you're trying to register your trademark. So when you register it, what really happens? So what happens is you are given exclusive rights to use it, assign and license the mark, right? So when we say assign, what we really mean is to sell it, okay? When we say license it, it means you can rent it out, right? So these are some of the legal words that are used, but what these words really mean is that, right? So as the owner, when you register your trademark, you can keep using it, or you can sell it, or you can also rent it for a specific period of time. These are all possible. So as when you register it, you can go for civil and criminal court procedures are both available to you. So what we mean by civil means, let's say I have a specific trademark and you use my trademark on your products. So a civil action would mean I can claim for damages. So we'll be discussing a little bit about how you go and get that sorted out, right? What's the procedure and things like that. A criminal court procedure is where if you have made a product which is very similar to the product I have made, then I can claim for a counterfeit goods or forgery. So that's what we mean by criminal court procedure. So both of these options are really available to us. Also, the owner has the ability, once you've registered, to restrain other people from using that particular mark. You can't use it because that's my trademark, or even deceptively similar marks. Because I think you would have seen this whenever we travel out of Colombo, you would see the Food City logo being almost deceptively resembling, right? And but this Food City is not actually the Cargill's Food City, but you might have like Aryadasa Food City, but the Food City lettering is so much similar to the Cargill's Food City kind of name, right? So I'm sure you would have many other examples that you would have come across, right? And also, I think if you go to China, it's the amount of counterfeit goods are like numerous, right? They have a specific market which sells and specializes in selling counterfeit products. And they make replicas of them, right? So here there's really a clear infringement of trademarks. So when you register, what is the period of protection that you get? So what's important to remember, from each of these 4 intellectual properties that we are talking about, the registration gives you various coverage periods. So when it comes to trademark, you are protected for 10 years and it is renewable, right? So you can renew again for another 10 years. So you can go on like that, but it's protected generally for a period of 10 years. But if you don't use that trademark for a continuous period of 5 years, then you can then if there's someone else who wants to use that, they can apply to court and get that registration basically cancelled out, and they can commence using it. So we'll be talking a little bit about, let me give you some kind of background, or like some kind of, let's say, practical aspects of trademarks. So I'm sure you all are all familiar with Kotmale, right? Kotmale, as you all know, it produces milk, yogurt, butter, cheese, things like that, right? So generally, when you register a trademark, you can prevent similar goods which another person cannot make by using that name Kotmale, right? But let's say somebody comes up with Kotmale shoes, right? So now this is completely dissimilar to the Kotmale goods which we generally know, which are to be milk, cheese, yogurt, so on, right? So in some instances, it may be permitted to use the trademark Kotmale shoes. But there are certain instances, for example, if it's a well-known mark, right? So I think if I give you the example, then you will understand what do I really mean by a well-known mark, right? So there was a case that happened with regards to Everready. I'm sure all of you know Everready, right? They are into batteries and torches. And so Everready had registered their trademark of Everready. So there are under batteries and torches and other similar products, right? So you can understand when you say batteries and torches and other similar products, it means products within those kind of ranges, right? So here was a company that was producing the same name, Everready, but the products that they were selling was condoms. So it's really quite dissimilar to torches and batteries, right? But here, what the court held was that it is a violation of the intellectual property rights of Everready. And really the argument is that Everready is a well-known mark, and even though the goods are dissimilar, meaning batteries and torches versus condoms, so completely dissimilar goods, but still what this organization is doing is they're relying on the reputation of the well-known mark to get an unfair advantage in the marketing of their goods, right? And therefore, it was considered as a violation, right? So you can see that in most times, if the general principle is if the goods are dissimilar, they do allow you to register a trademark. But if it's a well-known mark, like Everready, where globally everybody knows that brand, right? And everybody knows of Everready batteries and torches and so on. So then what they said is then what you're trying to do is you're relying on that reputation of that well-known mark. So in certain instances, it may be rejected and also you may be sued for using that well-known mark, right? Even though the products are completely dissimilar. Another important thing that we have to talk about when it comes to trademarks is this thing called NICE classification. Okay, it's actually spelled NICE, but we call it as we pronounce it as NICE, right? So this NICE classification basically has all the goods and services that are traded, right? And they are actually classified into 45 classes. So all the goods are categorized into various classes, right? So 1 to 30 contains the goods aspect, 31 to 45 relates to services. So in each of these class, you have like subclasses with the list of in this class what are the stuff that are kind of captured, right? So so when you are registering for a trademark, you can register for any of these classes, right? So if you are registering like for example the brand like Kotmale, you can put for all of these like consumable edible products of milk, cheese, yogurt, and such similar products. So when you say such similar products, it means that range. But if you also want to, there are other classes that you can really go and register this name of Kotmale. So in Sri Lanka, when you are registering, for each class, you need to pay, if I'm not mistaken, 1,150 rupees, right? For each class. So there are 45 classes. If you want to register for all 45, then it's 1,150 multiplied by 45. So it depends on the number of classes that you want to register your trademark with. As I told you, even sometimes though you may have not registered for a particular class, if your brand is a well-known brand and someone else uses that brand's reputation, then even though you have not registered for that particular class, you are still entitled to sue for intellectual rights infringements, right? Any questions for me so far? Let me just quickly go to the chat also.
So far seems good.
All right. Okay, fine. So there's nothing on the chat as well. Okay. So that's a little bit about trademarks. So why are we really registering? What's the purpose of it? So that's what I kind of wanted to share with you all. If I can move to the next slide. I seem to have got stuck. Right. So this is about registered versus unregistered. So what really is the purpose of doing it, right? So generally, what do we mean by registered? If you are registered in the National Intellectual Property Office, under the law, it's considered a registered mark. So now I have a question for you all. If I register it in Sri Lanka, right, will my registered trademark be valid in India? I can repeat the question. If I register my trademark in the National Intellectual Property Office in Sri Lanka, will my trademark, the registered trademark, be valid in India?
It won't, because the countries are different unless you have it under a common forum which recognizes these trademarks in another country.
Correct. So what we have to do is, if you are going to work with those any other country, you need to go and register it with that specific country's intellectual property office, right? So please remember, trademarks are territorial. So if you register it in a particular territory, then that's it, right? You want to go to another territory, then you have to go to that specific country's intellectual property office and register the mark. So that's important to remember. So as I told you, when your trademark is registered, you would have that R, and within that, like a circle around it, right? You would have that symbol placed when you have registered that particular trademark in that particular country, right? So then you would consider it as a registered trademark. But you can even use a trademark without registration, right? Even unregistered marks can be protected under the unfair competition law, or as per case law for passing off. So what I'm really doing is I'm passing off my goods as someone else's goods, right? So even though your trademark is not registered, no big deal. Even if it's unregistered, you are protected. But the only issue is the procedure for court action to rectify the unfair advantage that has happened to the other party is different. So that's why we always encourage companies to register. So when it's registered, remember, you have the exclusive right to use, assign, and license the mark. So these rights are easily enforced in the civil or criminal court procedure, right? So you can go to the Commercial High Court of Sri Lanka, especially if you have a registered trademark, then it's an easy application. But when it's unregistered, then the process is longer, because here you can simply show your registered documents, and it's a matter of it's very easy to decide. It doesn't take long, right? You have registered, you are using mine without my approval, fine. Unfair advantage has taken place. How much are you claiming for? And some portion of it or all of it will be given to you, right? But that's not the case when it's unregistered. When it's unregistered, you first need to prove that you've been using this trademark. How long have you been using this trademark? So it takes you all of that background work which needs to get done, right? Because the other person can always say, I also started having this on this particular time frame. See, this is the first instance I used it. So then this big tussle of who had been using it first comes in. So that's why we always say it takes a little bit more longer. And as I told you, it's not very costly to register as well. And there are enough people to support you to go and register a trademark. So if you do something like that, then it makes the everyday business that much more easier, right? So you don't have to have this hassle of trying to prove who used this trademark first, right? And why do I say this trademark belongs to me and not to you, right? So that process is eliminated when you have registered. So as I told you, you can prevent others from using your mark. So some people would use your mark as is, or some people will make deceptively similar marks, right? I think there were certain cases which you would have known of earlier, Sirasa TV, or was it? No, the English channel was known as MTV. Can you remember that period? It was known as MTV. It wasn't known as News First or anything like that, right? It was known as Maharaja Television Network. But in the early 2000s or late 90s, I remember MTV got to know that Maharaja TV was using the MTV, the three letters. And even though they were not similar, because MTV had a big M and TV was, smaller. But Maharaja had MTV in all, three big letters, but they were all in the same industry, right? Of television. So actually, they had to change their name, and that's when they initially became a News First. Then that's when they became News First, and for a certain period of time, they also went as Channel One MTV, and then later on they converted their name. So those are really some instances where initially you may be happily going along with somebody else's, deceptively resembling the mark, and maybe it really wasn't your intention to deceive anyone. It was simply the surname of that family, Maharaja, and it's Maharaja TV. It was simply that. But the fact of the matter was that there was a well-known brand by the name of MTV or Music TV. And because of that, there was a intellectual property infringement case, and they came to a settlement in this regard, and then they, fixed it. I think there was a similar thing in Sri Lanka as well with regards to Rupavahini, again related to a talent show, again for the use of those same words, because sometimes Sri Lanka, either they are unaware or they don't care, either of the two. They use the same things like American Idol, right? So you use those kind of specific TV program names, just thinking that it's just for, no one is going to know, it doesn't really matter kind of thing. But those are kind of prevented. Those are trademarked, protected, specific TV programs, right? And even that logo, American Idol, or you also have other things, or so many Voice, there's so many others, right? All of those are really trademark registered intellectual property. So this is the reason why we say to register. So if you register, then you can easily show your registration certificate, and that tells you from how and that you have been approved by the Sri Lankan or from that particular territory, from the National Intellectual Property Office. So you are given priority, right? Okay, so if you are looking for protection abroad, how do you go about it, right? So Marks registered in Sri Lanka are valid only in the territory of Sri Lanka. If you do business in other countries, then you need to register those marks in those countries, right? So applications should be filed in each country, and you're seeking basically protection under that respective national law. So there is something called the Madrid Protocol, but Sri Lanka is not a member of this Madrid Protocol. So if you are a member and say you are an applicant, you can make one single application, right? In your country, you can then make one single application, and a fee is calculated according to the countries you want. So for example, say I want for Maldives and I want for Singapore and so on. And if they are also part of this Madrid protocol, then a single fee is calculated from the Sri Lanka Intellectual Property Office, and you can pay that amount, and then it can be protected, right, for over 114 member states. So Sri Lanka has still not signed into this Madrid protocol. We have actually only signed in for 3, the Bern, Paris, and TRIPS. Those are the 3 protocols that we have signed in for. Okay. So how do you register a trademark? So there's a form 1. Actually, I have always put the source of where I am taking all of this. So if you are interested, you can go to National Intellectual Property Office, government.lk, and this website really is a great guide. It tells you about copyrights, it tells you about trademarks, patents. It also talks to you about who are the registered agents. So agents are really help you to fill these applications. And you can go and register. If you're a lawyer, you can go and register as an agent who is filling these applications on behalf of the applicants, right? But it doesn't need you necessarily need a lawyer. You can always do it on your own as well. And there are enough guidance on the website as to how to go about it, right? So there's this form M1, which you need to file. And also this form will indicate where you need to give specific details about your trademark or your service mark, the font you use, the size you use, the colors you use, and like copies of them where you need to attach, and so on and so forth, right? So that is how it's generally done. So when you give this application, the office actually examines them, right? So it examines to see whether you have filled your form correctly, given all the necessary documents, so on and so forth. And they will also check to see whether your trademark is admissible or not. So there are certain things where it will not be admissible. So what do you mean by not admissible? It could be that my trademark looks similar to someone else's trademark. So then it will get rejected. Or maybe the names I'm using have something to do that it shows that I have some kind of state patronage or governmental backing or something like that, right? So then they need to check whether it's admissible or not, especially when it comes to companies' names and you're trying to register and so on and so forth, right? So generally your application, it can get rejected as well. And if it does get rejected, you have like 1 month to kind of give your submissions as to, so they will give you reasons as to why they reject it, and you can also put answers to it as to why you're answering some, or you have forgotten to attach something, and so on and so forth. And if it's still rejected and you're dissatisfied, then you can go to the Commercial High Court of Colombo and challenge that decision given by the National Intellectual Property Office, right? The mark is first accepted for the publication in the Gazette. So the process is, once your application is received, it is examined and it is given the go-ahead, then it gets publication in the Gazette. So it's basically published in the Gazettes. And you are given 3 months to write any form of opposition. So, for example, if there's a company that feels no, this trademark should not be used because it's deceptively like the one that I have, or for some other kind of reasons that they may have, it's going to cause an unfair competition, because even though we are not having the similar goods, you'll be relying on my company reputation to sell your products, any kind of opposition like that. They have 3 months, right? So what happens is, if you have oppositions, you write straight to the National Intellectual Property Office, and um, the officers there will send this opposition, a copy of this opposition to the applicant as well, right? And what will happen is, in that instant, the applicant has to give reasons, right, as to why he will be opposing some of these things that have been made against him, right? So you also have the opportunity to, initially it's all about documents, right? So if a person opposes it, they will, in writing, give their reasons for opposition to the National Intellectual Property Office. A copy of your opposition is given to the applicant. Then the applicant also can write his side of the story, right? So these are actually all filed. And what happens is, now you have two people on opposing sides, they will have a small inquiry. So the Intellectual Property Office will have a small inquiry to check into these oppositions with the participation of the applicants and the person who's opposing it. So after this inquiry, they can either register it, or they can refuse to register this trademark. If it is refused, you always can challenge the decision in the court. So whenever we say the court, what we're talking about is the Commercial High Court of Colombo, right? So if you're ever dissatisfied by a decision given by the Intellectual Property Office, then you go to the Commercial High Court of Colombo. So if it's accepted, then the registration will be processed, and you are supposed to pay a fee. I told you about each trademark for each class is 1,150, if I remember it right. Right. So it's not such a big amount. So if actually all these fees are at a very reasonable amount, that is to encourage, really to encourage entrepreneurship and to really build the intellectual property wealth in Sri Lanka, right? So you can then pay the fee and your trademark is registered. Any questions for me?
No, not at the moment. I might have something, but I'll call you on that in person if possible.
Okay, all right. Christo, anything?
No, ma'am.
Great. So I will move on. Right. So now we are talking about the second type of intellectual property, which is copyright. So copyright, so remember, trademark is a symbol, right, which distinguishes your particular goods and services from another company. Copyright is about the right given to creators or authors for their literary, dramatic, musical, and artistic works, right? So some examples could be scripts, could be novels, could be books, could be collection of poems. It could be scripts, teledrama scripts, drama scripts, movie scripts, any of those, musical lyrics, paintings, photographs. There's such a big gamut, right? Podcasts, all of this would fall under copyright. So for it to be considered as copyright, one of the first things is it has to be the author's own intellectual creation. So I can't put together things from various other people and then consider it as copyright, because that's really plagiarism, right? Because now I have taken off other people. But this really has to be your own intellectual creation. So generally copyright has two forms of rights. There's something called an economic right and another thing called the moral rights. So what do we mean by an economic right? Economic rights include the right to reproduce, distribute, rent, or lend, perform in public, communicate to the public, and translate. Let me break each of these words down, right? So, what do we really mean by reproduce? So, let's say I have written a novel, right? I have written a novel, and reproducing simply means I am going to produce copies of this. So, say I am going to produce copies of it, I can give this reproduction right to a particular company. Like I will give it to Vijitayapa or Bloomsburg or any publishing house, the right to reproduce, right? But if that same company wants to sell it in a particular locality, then it's called distribution, right? That is the distribution right. So you can give the reproduction um, to a particular publishing house, right? The distribution also you can give it to that particular publishing house, and you can even curtail them to say you can only distribute in Sri Lanka or you can only distribute in the states, right?
We can't hear you.
Oh, can you hear me now? Hold on, I think I'm having a Wi-Fi issue. I can see that I have had a sudden drop. Hold on. Let me see if I can fix this. Can you hear me now? Is it clear?
Yes, can hear you, but we can't see the screen.
Yes. Hold on a second. I seem to have got stuck. I think you can see my screen now. Let me take you to the correct slide. Right. So I'm going to keep it like this. For some odd reason, every time I go full screen, there's some kind of a issue. But let me try again. Yeah. Okay. So let me start with reproduce. What we mean by reproduce is uh, how you are able to reproduce or produce more copies of a particular work. So if we take a novel, it's the right to keep printing copies, right? So distribute means it's your right to sell it to in a particular location. So for example, let's say I have written a novel and I will give the reproduction right or the right to make copies to a particular publishing house like Vijitayapa, right? But I can also give them the distribution rights. Distribution simply means to sell, right? So I give to Vijitayapa the right to sell, and I can limit both these, the reproduction and the distribution right. I can say you are only Vijitayapa is only permitted to produce copy and sell, which is distribute, only in Sri Lanka. I can tie up with a similar different publishing house in UK, in Europe, in anywhere, in India, right? So there's no requirement where I have to give everything to one particular person, because remember, I as the owner have the economic rights to it. So I have the capability to carve it out in however way that I like. So reproduce really means to make copies. Distribute really means to sell. So rent, I think it's easy. So it's like it's a library or something where people go and rent it out, right? Or it can even be like e-journals where you write a journal and your journal is published in a particular like JSTOR or some other form of scholarly writing portal, and where you've kind of rented it out. So they have the ability to host your academic writings, things like that, right? The other is to perform in public. Now, this is very interesting. Then we always say perform in public. So performing in public means, say it's a song, a poem, or drama, or anything where you have the right to perform it to the public. Right? Communicate to the public also means it can also be in, so it's not a performance per se, right? But it's merely a communication to the public. So it can be in relation to electronic communication as well. So please remember, whenever we talk about performing or communicating, we also do mean electronically, right? And you also have the right to translate to however way you want. Another thing that I think it's important and something that is generally overlooked is we have lots of songs, and lots of people would sing any song that they like, and sometimes you even have bands, and these bands come to weddings and they perform a particular song, like you ask them, or you might even have an old uncle or auntie who suddenly gets up at a wedding and who starts singing, right? So what's really important here is to differentiate about performing in public, right? So if I am singing and it is for my family, or I'm singing for my friends, or or my purpose is for this company is having a talent show and I am singing for that purpose, then it is not considered a performance in public. And say I'm just an individual, I'm not gaining any money from it, but somebody pushes me at a wedding and I sing. Again, it's even though there are lots of other people there, it will not be considered a performance in public. But if you are a band and you are singing other people's songs, right, and you are getting an income from it, these are generally considered as a performance in public. So this same thing is also applicable when you sing certain things on YouTube and it becomes viral, right? Then the person who has the copyright for that particular lyrics or for that particular composition of music, for that particular arrangement, does have the ability to sue you for copyright infringement. Whether that happens practically is another question, because it's also virtually impossible to keep a tab, and as to whether it has any economic benefit. So in really pursuing it, right? But it's important to note, that's why sometimes when a singer is singing somebody else's song, they might say things like, I have permission from XYZ to sing this song, and then only will they perform it in public. So it's also important to know that sometimes we assume that it's the singer who has the copyright. It may be not so. It may be someone else who has the copyright, the person who wrote the lyrics, the person who made that musical arrangement, right? So sometimes you don't need to really get permission from that singer. What you need to get permission is from the person holding that copyright license, right? So that's important to remember. The other is when it comes to moral rights, what does that mean? So we've really spoken a lot about the economic rights, right? Our right to reproduce or to make copies, our right to distribute or to sell, to rent, to perform in public, to communicate, and also to translate to whatever languages that we want to. So those are all economic rights. Moral rights are the right of the creator or the person who is the author, and you can always claim authorship. Why? Because you are the creator of this intellectual property, and you also have the right to oppose distortion or mutilation. So sometimes you may sell your economic rights, but remember your moral rights will always remain with the author. So therefore, even if somebody is trying to distort it, mutilate the work, make the plot different, and then make a teledrama based on it and all of that, you have the right to oppose those kind of distortions or mutilations of the work, because as the author, you will always have the moral rights to your intellectual property. So generally speaking, the person who authors it or the person who creates this intellectual property is considered as the author and is the first owner of the economic rights. But there is an exception, and that exception is if you are an employee and you create, let's say, policies and procedures, you create a specific audit tool with them, or let's say you are working for their engineering team and you develop a particular invention, okay, all of those, but let me come to patents and industrial designs a little later. I think I'm getting a little ahead of myself. But even if you are an employee and you make all these policies, procedures, a specific audit tool, you write for them a nice tagline, right? You create a newsletter for them, all of them, then they are not considered the author's economic rights, right? Whatever that is created by an employee generally belongs to the employer. So that is important to remember. So economic rights, as I told you, can be assigned or licensed. So what does assigned means? Assigned means you can sell it or you can rent it out, right? But as I told you, the moral rights will always belong to the author, irrespective of the economic rights. So you can sell off your economic rights, but the moral rights will always belong to you and be with you. When it comes to copyright, and this is the only form of intellectual property where you don't need to register to get protection. Protection is given to you without any form of formality. You don't need to register anywhere in the world to get copyright protection. Copyright is generally given to you from the day that work is published and made available to the public. So if I write a poem and I put my name on it and say I publish it in a particular collection of poems or something like that, then from that day onwards, right, where I've made it available to the public, that is protected. So there's nothing special for me to do. Merely the creation of it and making it available to the public gives me copyright protection. And this is one of the key features of copyright, where no registration is required, which is different to trademark, because remember, in trademark, yes, even though an unregistered trademark is protected, Still you have to go to courts and fight it out to show who started using it first. And if you do want to avoid that, then you can register your trademark and you are given a protection for 10 years, which is renewable every 10 years, right? When it comes to copyright, in Sri Lanka, it is generally protected during the life of the author. So if that author lives to 70 years, then 70 years it will be there, and upon the death, then further 70 years. So if that person dies at 50, it's 50 plus 70. Okay, so during the entire life of the author and 70 years after his death, the copyright is protected. So that means it is his heirs who will be following up on in terms of this copyright, because the author has now passed away, right? So you can, as I told you, sell off your economic rights, but the moral rights will always remain with the author. Any questions for me with regards to copyright? Or anything else with anything that we have discussed?
So far, all good.
Okay.
I just want to know, in my kind of a jewelry thing,
Yes.
mine would go into industrial like IP, right? Not the copyright per se, because this is more for literary works or something that's authored by someone.
Yes, but I think the shop name would fall under a trademark.
Yeah, that I'm aware. Yeah.
Yes.
Okay.
And the others would be, yes, the aesthetic appearance and all would be more to do with the industrial design. Correct.
That way, no?
Yes.
Yeah. Okay.
Right. So now let's move on to the third one, and that is designs. So as I told you, industrial designs is the ornamental or aesthetic aspect of an article. So even though you have this term industrial design, please don't get confused with thinking this is about the technology behind a particular thing or a particular industrial design. No, this is really about the aesthetic appearance of an article. So it has no functional character. That is important to know. So I think some of the most easiest examples that we can easily relate to would be different types of vehicles, the car models, right? How different each of them are, and all of them have been registered for industrial design for their aesthetic appearance. Or even when it comes to iPhone, how iPhone has this little, knob in the middle kind of thing. So that is really an industrial design. It has really nothing to do with the functional character of that article or of that product. So a design, it can be a three-dimensional. It can be a shape of an article, right? So for example, a design for a toy, a bottle, jewelry, chair, right? All of these, which causes this three-dimensional appearance, right? Or it can even be a two-dimensional thing, like a pattern or lines. For example, even a design for a greeting card which has this particular aesthetic appeal can be registered as an industrial design. So industrial designs are not like copyright. Just because you made it, you are not protected, right? You have to go and register with the Intellectual Property Office. So I think there are lots, Toys R Us, so they have a lot of industrial designs put on some of their toys that they produce, right? Same for when it comes to jewelry, you have the luxury brands which have specified specific industrial designs, right? Even for chairs, like you take Herman Miller and things like that, specific aesthetic appearance. Now remember, it's not the functional character of your ability to tilt the chair, your ability to raise the seat, to raise the arms, ergonomic chairs. No, nothing to do with the function. It's to do with the appearance, the physical appearance or the ornamental value of that particular product or article. So here, when you go and register, remember it gives you only 5 years of protection, right? And you can renew it for 2 more terms of 5 years. So that means an industrial design's lifespan is actually only 15 years. So 5 years, again 5 years, and again 5 years, right? So that's generally the way when it comes to industrial design. And the owner of the design can exercise exclusive rights. So what do you mean by you can enjoy exclusive rights? You will be the only one who will be able to make with this particular industrial design. To use it for any of your products that you want to, right? And also you can restrict uh, imports coming in which has some kind of industrial design like that, right? And also exporting articles, right? So all of those are protected when it comes to these exclusive rights of an industrial design. But what is important to know is that when you are trying to register, the requirements for the industrial designs and the application is a little bit more process oriented, because you have to really indicate and show how this particular industrial design of yours is original, right? It's completely original, and that it is a design that has not been, like, it can't be a common industrial design, right? And where you try to go and say, you know, how a general chair has 4 legs and a seat to sit and a back, right? You can't sometimes go and just register simply the aesthetic appearance of a chair like that, right? Because it is too generic. So this industrial design has to have some form of specific features which really stands out uh, from the others. So from other chairs, because we all know a chair has 4 legs, a seat, and a back. You can add on arms and things like that, armrests and things like that, headrests and all. So it's these other features that pushes this um, aesthetic look to being original and unique. So you have to ensure that this particular industrial design that you are promoting, or that you want registered, is original in that sense, right? So generally there are people who support you to really make these applications, because unlike trademark is a little bit more straightforward, right? It's either a company name or a logo, and we all know how to get the printouts the way anybody would want, right? We know the font color, we know the font name, we know the font size, right? We know the placement of it. We can say it's 2 inch from here, a couple of millimeters from there. We can all create it, right? Easily. But when it comes to industrial designs, you would need a professional to help you, to guide you in this process, because every single minute detail of this particular design needs to be included. So this is a little bit more of a difficult process. But if you are interested in knowing more details on it, as I told you, you can visit the Sri Lankan office. But in that website itself, it's quite basic, but it gives you the general indications of what you need to do. And of course, you can speak to a lawyer who specializes in registering, because not everybody has experience doing these, right? Because as I have showed you the numbers in Sri Lanka, they are very small. I think there were 600 of industrial designs for 2019. So you can imagine the expertise in Sri Lanka in this regard is not that great, right? So, it's limited. Let's put it that way. It's limited, right? So it's always best to go to a person who has at least registered a couple of them before, because then they really know and are able to help you through these little pitfalls where your application may get rejected. Yes. So we are now moving on to any questions? Sorry. Okay. So I will take silence as no questions, and I will move on. So the next is really patents. So many people use this word, and I'm sure you all have heard of this as well. So patents really protect inventions. And what do we really mean by invention? Invention is a solution to a problem. So it has to be a practical solution. This can't be like an intellectual thought process kind of solution. This has to be a practical solution to a problem in the field of technology. So it's all about uh, the technological aspects of your product. So it can be a software development, a mobile application, it can be wearable technology, right? It can be with regards to a hybrid battery in a vehicle, with regards to door cooling refrigerators. It can also be with regards to any other forms of technological development. So it can also mean pharmaceutical things as well. I think you would have also heard about some companies in the States wanting to patent the COVID anti-COVID vaccination, and that was blocked or stopped because patents would mean that the other people are not allowed to manufacture. And in a time like this, that would really cause a lot of chaos to the world. So I think one of the key differences is, do you know who invented the seat belt? Does any of you know who invented the seat belt?
No.
So you know how the seat belt has like 3 points, right? You have 3 contact points of a seat belt, right? You take it up from your shoulder, it goes around your belly. So there's 1 point there, then 2 points on your like hips, right? So that is generally the a basic form of a seat belt, right? So it's called a 3-point seat belt, right? And it was actually developed by an engineer in Volvo, and his name was Niels Bohlin, right? And one of the greatest things about Volvo, and I think that's an important aspect of when to patent and when not to, is that Volvo decided not to patent it, but instead they decided to share that 3-point seat belt with every other single car manufacturer in the world, right? And that is why everybody has access to that seat belt design, right? And so this was really a practical problem, right? And it needed a solution, and they came up with it, but they decided not to patent it. And that is one of the reasons why everybody can travel safely. So there are pros and cons in terms of patents, because when you patent things out, there's also a way where you really restrict others from making it, right? So you can really exclude people from making it, from using it, from selling it, right? So if you do something like that, something like a COVID vaccination, you can imagine the kind of issues it's going to, the social issues it's going to really cause. So whilst patents are economically justified, and it is always justified by saying that many people have spent a lot of money and hours trying to invent this particular practical solution to a problem, right? So a lot of money has been spent, a lot of time has been spent. So as they invented it, the people who invented it should be given the right to make use of it and to make good commercial profit out of it, right? So that really is the basis for patent registration. So the moment you register a patent, you become the exclusive holder of that patent. You can make it, use it, sell it, right? So, and it's there for a period of 20 years. So what really it does is the government gives you a monopoly, right? So you are the only person who can do it for the next 20 years. So you can imagine the kind of economic benefit that particular company can make out of it. So I showed you the numbers in the States, right? So it comes in millions. So you can imagine the economic benefit of registering a patent, because it gives you this particular economic advantage for 20 years. It's after 20 years, anyone else is allowed to copy it, because they believe that within those 20 years, you have recovered any of the investment that you put into it. But apart from that, you would have also benefited or profited from it, right? So this is really a creation of a monopoly, and it has its advantages and it also has its disadvantages. And what's really important to see is, as much as there are patents are there for are being filed. The seat belt was an example that I gave you. There are many others like that too, where companies have decided not to pursue with that, because they felt that for the overall benefit of the public, maybe it's better not to patent it, right? So there are things like that as well. So when you are the owner of this registered patent, you can, as I said, use it or commercialize. So if you're commercializing it, what we are meaning is you are you can sell your reproduction rights, you can sell your distribution rights, right? You can rent it, licensing it, right? So basically, you have all these ways of really getting a big financial benefit, and it contributes to the growth of the economy as well, because that's actually the purpose in really patenting things. So even things like genetically modified animals, plants, things like that, they are encouraged to be patented, because once it is patented, then you really can create a lot of economic growth for that particular country. So please remember, as in every other intellectual property type that we are discussing, a patent is only valid in the country where it is granted. Please remember, the only exception is copyright, right? Copyright is wherever you are in the world, whatever it is, the moment you have created it and you put it to the public, then copyright, you don't need any form of registration. Copyright rights arising from copyright is commenced for you. But when it comes to trademarks, industrial designs, and patents, you need to register it, and it is territorial. So it is confined to the country which granted you this patent. And if you are going abroad, then you need to register it in those respective countries. So I think that brings us close to the intellectual property segment of our discussion today, right? Any questions so far? Any other comments or anything, any further information you would like to know? So if you're interested to know under a trademark, what are the classes, what is this needs classification, again, all of that is there in the Intellectual Property Office of Sri Lanka, where you can download those. If you want the application is there. If you want fee structures, the fee structures are there. I think another important thing that I forgot to mention to you is that when it comes to patents, as much as I told you, industrial designs has some technical nature. When you are registering a patent, it's way more complicated, right? Please remember, we are trying to register a specific technological solution. So there's a spec that we need to write. So this spec is really written by various professionals. One is, of course, the professionals attached to that specific technology that was developed, right? So if it was relating to pharmaceutical, then you would have relevant professionals in that field of study making that initial one, right? So there are lots of like you have to really spend a lot of money to get this patent registered, because the requirements, the documents required for submission are very technical in nature, which requires the expertise and professional guidance of those specific individuals attached to that specific industry. So it could be pharmaceutical, it could be software, it could be genetically modified products, and so on and so forth, right? So the spec is very complicated, and these are also it's good recommended practice to go for with people, whilst the professional skill that you're using for that particular sector may be one of your own employees, or it could be someone who knows the technology, but there are other aspects which you would definitely need to go with a lawyer who is experienced in filing and getting those patents registered, because they will then guide you in those relevant steps, because this is a little bit more complicated and it takes time to register. Because to be honest, in Sri Lanka, sometimes some of these trademarks also takes a long time to register, like 3 years. Okay, I'm not trying to like discourage you from doing it, but that is the practical aspects of it. It does take a long time for it to come through again. Some people have taken as long as 3 years, whilst for some people it has been short as well, right? But for patents, it takes a little bit time, and that's why it's important to get the application right in the first go, because once they get it, they need to do all of this examination. And for these examinations, it's important that you have produced the relevant documents. Right. That was something I missed to mention earlier. Any other questions for me?
No, not that I have.
Okay. So we have a few 25 more minutes. So I'm going to close up intellectual property with this particular slide, and I'm going to move on to another topic that we have. And no, I think I have one more slide. I think as a business person, what are the things that you need to watch out for when it comes to intellectual property? So one of the key things is, if you are an entrepreneur or you're a business person, right, having a business, what's one of the key things to please remember is that do not use pirated versions of software, because Microsoft comes down very hard on companies that are using pirated software. Individuals, not so much, but when it comes to companies, they really do come hard on you, right? And they have various ways of tracking to see the kind of versions that you're using. So please make sure you're using licensed versions, because in Sri Lanka, some companies decide to do this. And I also know that sometimes you have employees who just simply download pirated versions of a particular software. It can be AutoCAD or something like that, which they want to use for a specific thing. I mean, it's not available for them, so they just simply download. But if you are a company, Microsoft keeps a very good eye, and you will be sent a letter of demand. And I have seen that happening to various companies, right? So that's one thing really to watch out for. The other is, if you're a company and you're really looking to, spruce up your website, and you want to make a flyer or things like that, please be careful of the images that you use from the internet, right? There is stock photo galleries where you can pay and get the license to use that particular image, or you can even give credit to the image that you have taken. So sometimes you may have seen there's an image, and at the bottom of that image in very small font, you would have some kind of credit being given, license under so and so kind of thing, right? So be careful. There's a company that I am aware of. They were into advertising, and they used this famous picture. which was circulating in social media, and they nearly because they are an advertising company, a client had come to them for a advertising campaign, and they used this picture which was circulating, and the person who had the copyright to this photograph actually sued the client because they don't know whether it was advertising firm or whatever that created it, right? As far as they are concerned, this particular ABC company is using my photograph without, without any kind of payment being made to me. So be mindful, especially if you're a business owner engaged in those kind of things. You have to be careful because it's those flyers and things which you create, which your clients may be using. And if this happens to your client in turn will be suing you because they expected you to have looked into all of these things before you gave them an end product. So please be mindful of some of the practical downfalls that we can have. The other is deceptive use of a mark. So I spoke to you about how Maharaja TV changed to News First. Similar thing also happened to Courtyard by Marriott. Earlier, that's how it was known as. There was it was called Courtyard Colombo, but courtyard is a word that was coined by Marriott, and Marriott uses it around the world globally for some of their hotels and spas, right? So when Colombo Courtyard used that word, they got sued by a Courtyard by Marriott, right? And they came in for a settlement. They had to change their name, and they now go as Colombo Court, right? So these are really some of these issues that you might come up with. Some people initially would be like, it doesn't matter, they're not going to find out, but the world is so small, and companies really don't want you palming off their work in the same way. See, the thing is, had you used Courtyard for a badminton, a sports thing, or anything like that, they would not have pursued it. But the fact is that Colombo Court was also a hotel, and they were using this Courtyard Colombo. So that was the issue. But if it was, used for a restaurant, Courtyard, or if it was even a restaurant, might be an issue because it's kind of related to the hotel and spa industry. But if you used it for something completely dissimilar, like a sports facility, a sports complex, or a playground or something like that, then they would probably not have sued. Then we also spoke about singing or sampling another musician's song in public, right? So this is also some things to watch for, especially if your business is into these kind of activities, be it a musical band or anything like that. It's a matter of being aware, and it's a matter of also reaching out to the people that you can to ask, is it okay if I perform, right? And if they do say that, just get that in email or text form or some form in writing, and then it's good. And you can also give credit to them in your performance. So those are some things to really watch for when it comes to intellectual property. Right. So I think now it really does brings us to a close with regards to intellectual property. So I want to move on to one last thing, that is with regards to contract law, and why is it important to effectively manage contracts if you are an entrepreneur, right? So generally, I'm not going to go a lot into detail with regards to what makes a contract and so on. But what I want you all to know is some very basic things, right? Contract law is not governed by a particular act or a legislation or a statute, right? Remember, we said intellectual property was governed by the Intellectual Property Act of 2006. Like that, contract law doesn't have a specific law, but rather we are following case law or judge-made law or common law, right? I'm just giving you that because don't go looking for a contract law legislation or a contract law statute. You are not going to find one, okay? A contract can be in writing or it can even be oral. So just two people agreeing on something can also be considered as a contract. Okay, so there are a couple of things that needs to come together for it to be considered a contract. There are actually 6 particular things. If all of these 6 falls in, that's when we can call it a contract, and you can enforce this contract in law, right? That means you can sue a person. So even to sue a person, it doesn't have to be in writing, it can be oral as well. But of course, we always recommend it to be in writing because it's so difficult to prove oral, right? So one is there has to be an offer. So the offer is let's say I have 100 tons of sugar, right? And I'm going to sell it at this price, right? Acceptance is that person saying, okay, I will buy them at this particular price. Okay. Consideration means when they are buying, they will give me something. There's an exchange happening between the two parties. I give sugar, you give me cash. Or I give sugar, you give me potato. It doesn't matter what it is, as long as there is something passing, something that we would consider as adequate payment, right? So the law doesn't really bother about whether you paid me in potatoes or whether you paid me in money or whether you paid me enough money. Also, they are not bothered. As long as both of us are in agreement to what is passing between us, we are fine. So consideration really means payment. Something is exchanging, right? The other is that we had the intention for it to be legally enforceable. For example, it's not just a random promise that we've made. Like, for example, a random promise is I could say something like, or sometimes parents say things like, if you pass this exam really well, I'll take you to a movie or I'll take you uh, your favorite restaurant, something like this, right? So this really has no intention of legal force, right? So the parent nor does the child think that if you don't deliver upon this, I will sue you, right? No, nobody thinks that because they know it's just a promise, just an informal kind of negotiation that is kind of happening. So when you are two people talking about business, then we generally talk about this intention to have some kind of legal repercussions if I don't do that. For example, I'm giving you sugar. If you don't give me the potatoes that I want, then I will sue you because I'm giving you something, expecting something in return, and I need you to give that in that quality, in that pricing, whatever that we've agreed upon, right? So legality of the contract means is whatever that we are getting ourselves into this contract must be legal. For example, I can't get into a contract with you where I would ask some kind of an illegal thing to be done, right? And if that is not done, I can't go and sue you in courts. For example, I am asking you to supply me ganja, right? So or marijuana or something like that, right? But that in itself is an illegal act. So if I give you the money, but you don't give me the marijuana, then I do not have the option of going to court and suing you because our contract in itself was illegal, right? The last one is legal capacity. Legal capacity means both of us should be above 18 years of age. That's one, right? Do we really have the ability to get into this contract, right? So 18 years of age is one. The second is our mental status. Are both of us in good, are either of us having any kind of a mental impairment, right? So for example, if there are people who have a mental impairment, then even though you have agreed into you will sell me your property and I will pay you something, the law will see it as this person who entered into this particular contract had no legal capacity to enter into this particular contract, and that will be dismissed, right? So these 6 elements has to be in there for you to say you got into a contract, right? Having covered that, what are the things that you need to be aware of? So there are actually three things as an entrepreneur that you would generally need to know. One is the supplier contracts that you get into, right? The other is employment contracts, and the third is non-disclosure agreements, or we call them as NDAs. These are generally important aspects of contracts for an entrepreneur. I will not talk about employment contracts today, because when we are discussing employment law, we will be discussing that aspect of it. But I do want to spend a few minutes talking about supplier contracts. So even if you don't have the money to go to a lawyer and get your supplier contracts sorted out, there are some basics that you can do on your own. And these are some of the features that I have put in, right? So please make sure that the contracts you're getting into are in written form. So even you might not know all the big legal jargons and what to put, but you can always put the basics that you want covered, right? For example, the name and address of both the parties, right? The time frame. So when are you expecting this delivery? When are you supposed to pay? And other types of responsibilities, right? For example, a supplier contract can be in relation to a construction or something like that. So what are their responsibilities? Are they supposed to buy the material, or am I providing material, right? So you set out their very basic responsibilities. Then with regards to pricing and payment details, right? So pricing is very important, and you need to put that in. Also, any other kind of quality requirements that you have, right? So for example, if you're buying produce or any kind of thing, you want to check the quality. In your little contract, you can have a small clause saying that as soon as the quality is agreed upon, right, you have to show a sample, and that sample quality is agreed upon. That's the quality that's expected, right? Something simple like that, that gives you some form of reference that, yes, we spoke about quality as well. Then with regards to payments, when are you supposed to pay? I'll give you a credit period of 30 days or 15 days, 2 weeks, or as soon as delivery happens. What is that? What is that? And make those kind of details known. Then in terms of performance criteria, right? So what we mean by performance is, again, you may have certain supplier contracts with regards to artists who are making a particular product for you, or things like that. So then you can put out those that you're expecting the spec or that product to have these kind of outputs, right? That you want it to be artistically as per the design that was given. You expect it to be smooth. You expect it. What is that performance that you're expecting out of this person, right? You want it to be neat, and if there are other specific technical language that you can use to explore those, then you put those as well, right? And then with regards to confidentiality, right, that this pricing information is to be kept confident, right? Or with other any kind of other details, right? The name of the clients and all, you are not allowed to circulate or use for your own advantage, things like that. Then, of course, another important thing is refunds and compensation terms. So if you don't deliver something on a particular date, when does surcharge kick in? Or can I get a refund? And how will you pay me that refund? When will you pay me? What's the time frame? Or also in terms of compensation, say you've given me produce which are of poor quality, then how will you compensate me for it, right? Then is there a thing in the next order we are reducing, or how are we going to go about it, right? So all of that you can also at, at least talk about these things when you're entering into a contract, right? So at least be aware to verbally even have chats like this and then put it into paper. So maybe sometimes when we're entering into an agreement with someone, we might not talk about these things, but at least this will be a guide for you to know these are things I need to talk about, and these are things I need to put it into paper, right? So that paper can just be an email, even a simple email setting these things out. And of course, you need a response back from that person saying, yes, I'm agreeable to this, to these, terms that you have specified, kind of thing. Then sometimes it could even mean level of after sales service. So for example, if this, you say I'm selling, you are buying products from a particular person, it can be electrical goods or something, and you are reselling it, right? So when you're buying things from them, say your clients return them to you saying it's not working, then what is your contract with your supplier? How does that work, right? Will they have technicians who you can use to make this product, right? And then give it back to the client, right? Because the client doesn't need to know all these back-end details of your workings, but you need to know what is their level of after sales service. Or if it's, let's say, a supplier making you particular software developments, then as and when you need upgrades done to your software, what's the level of service, what's the rates we are looking at, things like that. So you can also look at ways of renewing your contract or also exiting. Let's say it's not working out, you just want to get away from this now, then how do you do that? You can say, you can give, each party can give 2 months notice, 2 months calendar notice. Calendar notice means exactly the number of days in that month. So if it's October, it's exactly 31 days, things like that, right? So calendar month's notice that you are expecting. So those are some things for you to really talk about with your contractors, and include those. It doesn't have to be a legally drafted contract. And please use simple language that you feel both of you understand as to what is required from you. Please don't go to copy paste the contract clauses from the internet and poke it in, because sometimes you think, oh, this sounds really great, and you put it in. But if you don't know the legal terminology that they have used, and you have misunderstood and put things, then you fall into trouble. So I gave you some words with regards to what do we mean legally when we say assigned, what do we mean when we say licensed, right? So if you don't know those words, don't go to use them. Just use words that you know, right? Which are simple and easy for both parties to understand. Right. So then non-disclosure. Non-disclosure is really great for startups when they are going to meet investors as well, right? Non-disclosures really means you prohibit someone from sharing confidential information, which you can define as to what are confidential information. So for example, when you are a startup and you have this great idea, right, and you are looking for investors, you go and pitch your idea to investors. But how if your investor doesn't want to work with you, but they go ahead and take your idea, right? So how do you prevent that kind of things from happening? That is where these non-disclosure agreements come in. So especially when it comes to software regarding things like that, because when you're going for an investor pitch, you are really pitching your entire product. So they really get to know the ins and outs. So you can get them to sign a non-disclosure agreements. But I will have to warn you, this is an agreement which I would not encourage you to do on your own. These are really agreements. The non-disclosure specifically is an agreement that you need to get a lawyer to draft for you, because these are clauses which are going to be enforceable in courts, and you need to make sure you put in the correct things and ensuring that your secrets, it can be your trade secrets, are all protected, right? So, this is really important for those who are going to meet potential investors, or you're looking for a prospective business partner. So you're like meeting a few, but you have to give them details, otherwise they won't invest in you. So how do you do that? Non-disclosure agreements are also important if you're taking on a consultant, because the consultant will get to know the ins and outs of your company, and also very sensitive data. So you need to make sure that this consultant keeps their mouth shut and that information doesn't leak out. So these are some instances where you will be using a non-disclosure agreements. Any questions from me with regards to contract or even with regards to employment law? These are really the basics with regards to contract. Any questions?
No,
ma'am.
no, I think it has been very clear, these parts. Thank you.
All right. So let me see who else. Christo, any questions?
No, ma'am. No, fine.
All right. So here are some of the links. So if you are interested, right, especially with regards to the intellectual property office, that's the last one, right? So this is a link that you can go to, really do your own digging to kind of understand what is best for me, which intellectual property should I go and register, and what's the process like and things like that. So I always give these links so that you have the ability to take steps into your own hands and follow through some of them, right? So what we discussed today was all in relation to intellectual property and a little introduction of sorts to contract law as is relevant for entrepreneurs, because contract law can be very complicated. But I think if you stick to the very basics of with regards to how you deal with your suppliers, and the others, of course, you may need support from lawyers to help you on. But writing down in an email, discussing the very basics of what you all agreed on are, of course, things that you can do on your own. So I'm going to stop at that. So it's 11:30. I am going to stop at that for today. I believe we have the last class next week. I think it's the Wednesday as well, but we will be starting a little late. I think it's around at 1, if I'm not mistaken. Yeah, we are starting at 1 and we'll be going on around till 3. Does any of you all have any issues with the timing or anything? Because I think this was communicated to you all before even this schedule started.
No, this was fine by me. The timing was fine by me.
Okay.
Yes,
Christoph?
yeah, fine.
All right, great.
No.
So then I will see you next week at 1. If there's any other kind of topic or anything that you would like to know, you want more information on, you can always write to the Edulink team and they will get in touch with me and I can cover those areas as well in our last class. So thank you very much for joining. Yes, and have a pleasant week and stay safe and stay at home.